Welcome to the forum, the All Souls UU Forum. My name is Craig Volland. I'm a member of the forum committee. The forum's mission is to afford a platform for the discussion of significant issues, especially those which involve ethical values in the contemporary world, and to promote critical thinking. And of course, the forum's been in operation for over 70 years. And in the last year and a half, we've been doing this over Zoom for the obvious reasons. And we're hoping that early next year, we could go back to on-site. I'm anxious for that because I like going over for lunch at the Cafe Sebastien. It's one of my favorite restaurants. So that's been real suffering on my part. But at any rate, this morning we really are privileged to have Bob I. He's been at the forum several times in the past on more than one subject, but the last time it was on the status of the struggle about women's rights in abortion. When we started talking about this program, we said, well, I think December would be, about December 5th would be an ideal time to do this. And sure enough, last week, Bob listened in to the arguments at the Supreme Court on the Mississippi case. Bob has represented the trust women in Wichita, and also Planned Parenthood in Overland Park. And he's also represented over the years individual providers. And so he's been right in the middle of this battle for decades, really. And so we really are lucky to have someone here who really knows what's he probably can't predict exactly what's gonna happen, but he's got a pretty good idea. So I'll turn it over to Bob.
Greg, thanks a lot for that introduction, and thank you everybody for allowing me some time to share my thoughts concerning the status of reproductive rights, not only in Kansas, Missouri, but nationally. I'd like to do three things today. First, I'd like to just do a kind of an overview of the status of reproductive rights now. With a focus, of course, on Kansas and Missouri, but I think it's necessary to give a reasonable treatment of this topic, to talk about some national trends as well. The second thing I'd like to do is do a review of the Dobbs versus Jackson hearing, which occurred Wednesday last. I did, as Craig mentioned, I did listen to the hearing, and it was a profound experience. And I'll go into a fair amount of a discussion about what happened during the hearing, and perhaps what it may tell us concerning the future of reproductive rights in our country. And that's the third thing I want to talk about. Where are reproductive rights going? What will happen if Roe goes away nationally and in Kansas and Missouri? And we have some pretty good ideas of what the future may look like under those scenarios, and I'll discuss those in some detail. Let's discuss a little bit about kind of the current state of play on reproductive rights. I mean, until the court rules on the Dobbs versus Jackson case, which was heard on Wednesday, and that's of course a challenge to the Mississippi statute that sets essentially a 6-week limit on when abortions can be obtained. You know, it's important to recognize that Roe, when it was decided in 1973, didn't happen in a vacuum. And if you go back 8 years from Roe to 1965, you can find the case of Griswold versus Connecticut. Griswold was the executive director of the Connecticut Planned Parenthood Association. And they were challenging a Connecticut statute that essentially banned the use of contraceptives, or banned or greatly restricted the distribution of contraceptives. The court took that case up, and in deciding it, put access to contraceptives on the level of a fundamental right. Now, they discussed what a fundamental right is, and it's really it's one that is elevated in terms of importance because, as the court put it, it's necessary to have such a right in order to be consistent with a civilized and developed society. Now, 8 years later, the Griswold case serves as a kind of a jumping off point for the court in Roe. And as we know, the Roe decision established right to abortion as a fundamental right. It also set up a trimester system to determine when states could intervene and restrict access to abortion. During the first trimester, there was essentially no basis for restrictions by states. During the second trimester, the state could impose restrictions so long as it didn't preclude access. And in the third trimester, there was essentially only in the instances to save the life of the mother could abortions be obtained. And then about 20 years later, Casey versus Planned Parenthood of Pennsylvania came along. And the importance of Casey essentially was that in an opinion written by Sandra Day O'Connor, it established the viability rule. And instead of just going on this rather nebulous trimester system, it got pretty specific. The court said that basically all restrictions on abortion before viability, that is before a fetus can survive outside the womb of a mother, restrictions on abortion pre-viability were not allowed. After viability, which most physicians determine viability to be somewhere in the 22 to 24 week period. After viability, states can impose restrictions, but they cannot do it so as to cause an undue burden to access. And this undue burden standard has been the playground, if you will, where state legislatures have been interacting, trying for years to figure out just how far they can restrict access without going past the line on undue burden. And it's produced a tremendous amount of litigation over the years, as you can imagine. Now, there's one other case, and I discussed this the last time I was with you a couple of years ago, in a case that was decided in 2019. It was the Whole Women's Health case, again, out of Texas. And the reason the Whole Women's Health was important was because it essentially said to state legislatures that were considering further restricting access to abortion, it said, if you're going to have restrictions, you've got to justify them on the basis of a health consideration. In other words, you can't start restricting abortions for non-health reasons. And that clarification sent the anti-choice movement into a bit of a panic. Because one of the things that they've been able to do over the years is set up these artificial restrictions that had nothing to do with health, had nothing to do with the well-being of the patient, but were designed to obstruct and confound access. And so there's that particular Whole Women's Health case I saw, and I think I said as much the last time I was with you, I saw it as a real watershed case, because for the first time, we had the Supreme Court directing state legislatures how far they could go in limiting access. At the time, as Craig mentioned, I was representing the Trust Women Foundation that owns the abortion clinic in Wichita. we looked at the whole women's health case and we said, this may be the means by which we can start rolling back non-health related restrictions on abortion in Kansas. And believe me, there are a lot of them that are not health related. And we actually went as far as to begin isolating particular statutory provisions that represent a non-health restriction to abortion and laying the groundwork for attacking those. And then Dobbs v. The Dobbs case out of Mississippi starts rearing its ugly head, and a lot of those plans have been put on hold as a result. At any rate, in Kansas, we have another protection for abortion. In 2019, our Supreme Court decided the Hodes versus Schmidt case. Many of you may know Herb Hodes, who was a longtime abortion provider in Kansas City, and he and his daughter both were providers, and Herb is now retired. But we brought that case in response to the statutory or the legislation that came down that year that said basically women could not have access to second trimester abortions that involved the standard techniques for ending an abortion through surgical means. And it was the procedure that is most commonly used. It was proved safe over and over, but the legislature said no, we would not be able to use that. We brought suit. We could have brought suit in federal court and gotten the thing taken care of pretty quickly, but the Kansas lawyers advocated to our national counterparts and our national colleagues that this was a case that should be brought in state court, and tried to use it as a backstop in case Roe went down. And in fact, in April 2019, our Kansas Supreme Court did in fact rule in our favor and said that there was an implied right to abortion. And more broadly speaking, there was an implied right to bodily autonomy that was in the Kansas Constitution, and that included access to abortion. The court was quick to note that this is not an absolute right, that there are reasonable restrictions that can still be imposed, but that it was elevated in the state constitution to a right that was protected. Well, for every action, there is an opposite equal reaction, not only in physics, but in politics. And the reaction in the state of Kansas was that the legislature, in its session last year, passed a resolution that would put on the primary election ballot in August of 2022 an amendment to the Constitution. It would specifically say the Kansas Constitution does not allow or does not protect the right to abortion access. The legislature passed that with 2/3 majority in both houses. It's going to go on the August primary ballot. You know, one could ask, I think, legitimately, why put it on the primary ballot? Well, the anti-choice people who spearheaded this effort in the legislature knew darn good and well that in primaries in Kansas, for every one Democrat that votes, you've got about 2.5 or 3 Republicans. And it was assumed that this would help assure passage. And I'll talk a little bit more about that particular effort in a bit, but know that that is a cloud hanging over the right of abortion in Kansas. In Missouri, the Missouri legislature went even further in its last session, and it, along with 10 or 12 other states, enacted something that's been called now trigger legislation. That legislation says that if the Supreme Court of the United States vacates Roe or repeals Roe, reverses it, then automatically, abortion will be banned in Missouri. So that's how close we are to having no access to abortion in Missouri and how close we might be in Kansas. And I said, I'll go into that a little bit greater in a moment. There are, I hasten to add, I mentioned I wanted to kind of bring a little bit of a national perspective to this. And there are a number of states in the United States, about, let's see, I think there's 14 plus District of Columbia, that do have robust protections for abortion access. I believe in the state of Washington's Constitution, there's a provision that says the right to access, abortion access, is guaranteed. Other states have statutory provisions, state of Illinois, for example. But there are only, like I say, 14 states plus the District of Columbia that presently, if Roe goes down, where access would still be available, presumably. And we got a taste of what these abortion islands might look like recently when the state of Texas took the opportunity in the context of the COVID crisis to close abortion clinics there. And you had this migration of patients coming to Trust Women's clinics in Oklahoma City, as long as it was allowed to be open, and in Wichita. And it was an extraordinary effort that those clinics had to go to meet those patients' needs. I think they went to a 2-shift schedule. It was an extraordinary challenge, and they rose to it. But it was a glimpse at what life might be like in a country that does not have Roe and Casey to protect access. And I'll also get into that a little bit greater in a moment. Let's talk a little bit about the hearing in the Dobbs v. Jackson case. And it's Dobbs, which is a Mississippi state official, against Jackson Women's Health Organization. Jackson Women's Health Organization is the last abortion provider in Mississippi. They're down to one, and the Mississippi legislature enacted a statute that essentially said once a fetal heartbeat could be detected, no abortion could be performed. This is usually about a 6-week event. After 6 weeks, some movement can be detected frequently, and that would preclude an abortion. And of course, at 6 weeks, many women do not know that they're pregnant. Women on contraception who still get pregnant certainly would be surprised to know that they're pregnant. And there are other circumstances that would reasonably interfere with a woman's capacity to know that they're pregnant at 6 weeks, let alone know enough in advance of 6 weeks to make arrangements to get off work, get childcare if they've got other kids, and to get the appointment at the clinic, and so forth and so on. So while the 6-week ban says 6 weeks, in effect, it's a lot more restrictive than even that in practical matters. The issue in Dobbs v. Jackson was seductively straightforward and simple. The issue in Jackson was, are all, I'm trying to read my own writing here. Are all pre-viability restrictions to abortion unconstitutional? Let me repeat that. Are all pre-viability restrictions on abortion constitutional? Now, the reason that viability came in is because nobody's going to argue at 6 weeks that a fetus is viable, period. Medical science has not advanced to the point where it can keep a fetus alive outside the womb at 6 weeks. So viability was immediately thrust into this discussion. As I said earlier, most physicians determine that viability is somewhere in the 22 to 24 weeks after the last menstrual period. Most providers that I've worked with will provide abortions up to about 21, weeks and 6 days. They won't go past that as a policy matter. There are provisions for late-term abortions, but they are very limited, and the process for obtaining a late-term abortion is very difficult. Even in most states, it still protects abortion rights otherwise. Here's how the court lined up, and there's no big secret here. You had the anti-choice, the avowed anti-choice faction, which consists of 5 justices: Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who really showed very little inclination to move off of their avowed position of overturning Roe. The only one that showed even an inkling, and it was just in a Q&A with the lawyer from the Center for Reproductive Rights, who represented the provider. In a Q&A, Gorsuch seemed to have a moment when he realized not only the magnitude of what they were being asked to do, but I think he allowed himself to glimpse into the future and think about the implications of having so many restrictions on access to abortion that would fundamentally change the character of our country. I think he had a glimpse of that. I don't expect it to be sufficient to see him move into the category that would retain Roe, but I practiced law for over 40 years, and I've been in a lot of appellate arguments that you walk out of them and you think, well, based upon the questions and the answers, we know what's going to happen in the decision, and be absolutely wrong in that prediction. So, but we have more than just this one argument to gain insight in terms of what these justices think about abortion access. So you have that group of 5. Then you have the group of 3, the Sotomayor, Kagan, and Breyer, who did a tremendous job at pointing out the implications of what rolling back Roe would mean. Their questions that they directed to the Solicitor General of Mississippi, who was representing the state, were not only a compilation of the court's accumulated jurisprudence on abortion, but they were prescient in terms of urging these justices to think about the future, to think about the implications of telling 1 out of 4 women in this country who've obtained an abortion that their rights don't matter. Now, unfortunately, as enlightened and articulate as Sotomayor, Kagan, and Breyer were, it did not seem to make much difference, as it turned out. With one wild card, you may have noticed, if you're keeping score at home, you may have noticed I haven't mentioned the Chief Justice Roberts. Chief Justice Roberts would like very much to find some middle ground here. He recognizes, and in a prior case that was decided in the abortion context just about a year ago, the Chief reiterated that under our system of stare decisis, that is where we use prior opinions and prior decisions to inform decisions on present controversies, that rolling back Roe would be a serious undermining of our system of using precedents to decide cases. And I can tell you this would be a profound change in our jurisprudence. Almost 50 years ago, when I was in law school, and lawyers prior to me and those subsequent have learned the law based upon precedent. It's predictive, it provides guidance for current disputes, and provides a continuity of law over time. Let me just contrast it with another system. About 20 years ago right now, I took a trip to Cuba with a group of judges and lawyers to learn about the Cuban legal system. In Cuba, criminal cases are tried by 3 judges who are selected by their worker collectives, and it's ad hoc. They go and listen to the case, and then they go back and talk to their worker colleagues about the evidence they've heard and how they ought to decide it. As I was hearing this described, because my background was really in criminal defense for many years, I kind of cringed because it was such a departure from the process that I was familiar with. I'm not, maybe it works for them. I think it's a pretty bad way to decide the life and liberty questions that come to pass in criminal cases. But in any event, Sotomayor and Kagan and Breyer, I think, were probably lonely voices. Justice Roberts recognizes that rolling back Roe on the terms of that are and the circumstances that present now would make the court look pretty political, not judicial. It would look like another political branch. And that would also undermine the very basis of our constitutional system. You know, the courts don't have anybody to go out and enforce their orders. They don't have the power of coercion, that is, and they don't have the power of the purse to do it. All they have is the power of the basis of the process that they've used and the perception that it's fair and that a decision has been rendered free of bias. Those perceptions are at stake, unfortunately. Now, I could go on for a long time about Dobbs v. Jackson because I took a bunch of notes, but I think that in the interest of time, what I'd like to do is discuss a little bit where we go if Roe is vacated, if it's reversed. And I think that the probabilities of that happening are actually pretty high now. Prior to the argument, I had some hope that there would be a chink in the armor of the anti-choice faction, but if it was there, it didn't reveal itself in any particularly obvious way. So where do we go? Well, as I mentioned earlier, most states, all but about 14 or so, most states in this country try to restrict abortion as much as they can get away with, as much as their body politic will allow. And if they are certainly given the free rein to restrict abortion up to and including a ban, I think you can figure that probably it would be probably in the area of 25 to 30 states that would probably exercise their right at that point to make a total ban on abortion. Now, if that happens, of course, we still have a few states, as I mentioned earlier, that do still protect abortion rights, but the ability of many women to get to one of those states is very limited. It's women of low income that are hurt the most. Their access will be, in many respects, eliminated. And as Craig knows, I grew up in a small town out in northwest Kansas. I grew up in Goodland. You know, abortion access in some place like western Kansas or eastern Colorado is kind of a nebulous concept anyway. Getting to Wichita or getting to Kansas City or getting to Denver is just not possible for some people. And so ending an unwanted pregnancy is something that just can't be done. And there was a time, I can remember after 1973, when Roe was decided, there was a robust discussion about how there would be providers, abortion providers, a plethora of providers. We would have the Dale Clintons down on 7th and Massachusetts Street in Lawrence, in his little office, providing abortion services. And there was, for a while, a bit of an increase in access. But that's when state legislatures began to get busy to roll these rights back. And it's been a constant struggle over the last 49 years since Roe was decided. There's tension between the rights established in Roe and the political prerogatives that anti-choice legislators have pursued to restrict access. So in Kansas, as I mentioned, on the August ballot next year, we will have the question that rolls whether we should say in our Constitution that abortion is not protected. That language is actually in a couple of other state constitutions. I believe Alabama has it. That as a matter of constitutional law, state constitutional law, abortion is not allowed. And I think Louisiana might have it. Now, there might be one or two other states. So we would be in the company of those states if the election goes the way the anti-choice people want to, where we would have specifically stated in our state constitution, abortion will not be a protected right. Now, if that is the case, it would then in turn allow our state legislature to ban abortion. They have the votes to do it. They have 2/3 majorities in both houses. And so if that election turns out to be a repudiation of the Hodes case and instead allows the legislature to ban abortion, my prediction would be that if the August 2022 election goes poorly for the pro-choice side, by the last week of January of 2023 or the first couple of weeks of February after the legislature's back in session, abortion will be history in our state. It'll be sooner in Missouri. The Dobbs v. Jackson case is going to get decided sometime before the last part of June of 2022. And if it's decided against Roe, then the trigger legislation in Missouri would immediately impose a ban on abortions. So abortion access in Missouri, as limited as it is, as tenuous as it is, would be over. And as I said, a few months later, it would be over in Kansas. Now, what do women do? As a practical matter, the closest providers then would be in Illinois and Colorado and New Mexico. That's it. Can you get yourself to, there's a provider in Western Illinois, it's just outside of East St. Louis. I can't remember the name of the city. And there are providers in Denver and Boulder and Albuquerque. That's it. I would not want to be a woman who needs to get an abortion because the hurdles to get it will be greater than ever. Now, there are a couple of things that I want to close on, just to provoke some thinking here a little bit. You know, it's one thing to ban abortion on paper and with all the weight that might be provided by the Supreme Court, but it's another thing to ban abortion in reality. You only have to think back to what the state of play for abortion rights were before Roe. People still got abortions. Rich people went to places where they could get abortions, or poor people risked procedures that might kill or maim them. That will probably be where we're at in a post Dobbs v. Jackson circumstance where Roe is rolled back. But I think that there are a couple of things that I think that some members of the court get and understand. Let's look at this in a little different way. You know, it's one thing to deny a right that's never had, or it's never enshrined in law. It's another to take a right away that has been protected, perhaps for generations. The example I frequently use in this regard is the prohibition on alcohol that was imposed constitutionally in our country in the 1920s. Think about how well that went. Yes, there was a legal prohibition on alcohol. What did it spur? It spurred a black market in alcohol, a black market economy in alcohol, violence, and it divided the country. And I think that abortion rights kind of fall in the same category. The other piece of this is it's troubling to think about how it would be enforced. How would a ban on abortion be enforced? Would it require physicians or women to report to the state their pregnancy, for it to be monitored, so that if the pregnancy didn't result in a full-term birth, there could be a prosecution? As outlandish as that sounds, there will have to be some enforcement mechanism to carry out a ban on abortion. I don't like to think a lot about what a society that would monitor women and physicians so closely as to consider their pregnancy and whether it's carried to term, what that society would look like. I don't think it's a society that any of us who are committed to constitutional rights and a society that's free and open can hardly abide. I want to just close before we open it up for questions. I just want to note that the commentators on this have been very interesting. Ross Douthat, who's the New York Times resident conservative columnist, in his column Sunday before last, he said, this is pretty close to verbatim quote, if Roe is repealed, it will cause a wave of social liberalism activism to wash over the country. Senators Maggie Hassan and Jeanne Shaheen gave speeches in just the last few days that said essentially the same thing. Eugene Robinson, columnist for the Chicago Tribune, in his latest a column that was published just a few days ago, said if Roe is pulled back, it will tear the country apart. And I think that those are all accurate statements. So, justices of the Supreme Court, although it may not seem like it, are people too. They read the newspaper. I suspect some of them even look forward to reading Ross Douthat's column each week in the Times on Sunday. Did they read the statement that their counterpart, Ross Douthat, or their conservative fellow traveler Ross Douthat, said that it would create a wash of social liberalism by young men and women? He was pretty specific, young men and women in this country. Will that deter them from doing this, from rolling back Roe, for fear of it triggering that kind of a backlash? I saw no indication of that during the argument. Now, again, arguments don't always indicate what will happen in the final decision. But we're about to confront a social change, if Roe goes away, that will be profound and long-lasting and will cause ripple effects, the likes of which we probably can't really imagine at this point. The only really reframing of it that I can see that presents any sort of optimistic view at all is that it would cause what Douthat and Senators Shaheen and Hassan said, that would be a worse circumstance than ever for conservatives or those who want to roll back personal rights. So we shall see. I I think a great deal about these matters and have been for a long time, as Craig said, decades. And I'm so proud of the activists and women's rights campaigners who have, for decades now, managed to hold back the flood of opposition to abortion in our country. Now, one thing I might add, the public opinion surveys that I'm familiar with, even in Kansas, show very high support for abortion rights. It's in the upper 50s, low 60% that would support maintaining abortion rights. And I think that that's true nationally. So you really do, the anti-choice people are there kind of, this is the tail wagging the dog problem. But just being a minority doesn't mean that they won't be able to have their way either in the court or in the legislatures. One thing that could happen that would also throw a wrench into this for the anti-choice people would be that Congress would enact essentially a national bill of abortion rights or bill of reproductive rights. That bill passed out of the House a couple of months ago. It's stuck in the Senate. It's going to require 60 votes unless they repeal a filibuster. And they don't even have all the Democrats on board. Senators Casey and Manchin are waffling. They've never been supporters of reproductive rights particularly. So even that looks doubtful, absent a big turnover in the Senate in 22. So that is how I see this playing out at this point, and I really appreciate your attention, and I'd be more than happy to try to answer any questions that you might have.
Okay, well, we'll just start with Richard. You go ahead.
Thanks, Craig. I may be outdated on this, but do you think that the Texas bystander law will be struck down that effectively bans anyone who in any way assists someone getting an abortion?
Yeah, Richard, I listened to those arguments as well. This lines up a little differently because I think this goes to the court's very power to do judicial review and other courts to engage in judicial review. My sense is that the Texas case may be moot if Roe is rolled back. That it would moot that altogether, and it just kicks it back to Texas. And if that's how they want to regulate abortion, they will. It's troubling because of the vigilante nature of the statute in Texas and the bounty hunter incentives that are in that act. But if Roe is rolled back and it's completely left back to the states, which is what Mississippi's lawyer said time and time again, this ought to be decided by the states. This is a states' rights matter. This is a state issue. And if that resonates with the court in the Dobbs case, then I think it'll moot whatever happens, whatever they need to do in the Texas case, because Roe will go away and Texas can just go do what they want, even as troubling as it is. I do think, however, that the court probably has a majority in the Texas case for providing some kind of a judicial remedy to review state statutes. I mean, there has to be some way for federal courts to review state legislative acts. And that's the nature of judicial review. And by the way, judicial review isn't specified in the Constitution either. It's an implied right. It was established through Marbury versus Madison a couple hundred years ago. Is that also up to question? I don't know. I mean, so I think the Texas case does represent an opportunity for the court to reestablish its jurisdiction for judicial review, but on the other hand, might not affect at all the substantive rights on abortion that are directly at issue there.
Okay, Evelyn.
Yes, hello. Thank you so much. Your talk was most informative. Thank you very much.
You're welcome.
But especially your comments about some commentators discussing the backlash of liberals if this decision comes down. Well, it'll be adverse in some ways. We just don't know how terribly adverse.
Right.
But I am wondering now, for me personally, all of a sudden I'm thinking we got to fix that court. We got to get more appointments of more liberals on there. Do you have an opinion if maybe that could be on the table, you know, enlarging the Supreme Court could be on the table if this is an adverse decision?
Yeah, I think it's inevitable. You're going to hear more and more discussion about it. I think you'll also hear discussion about bringing in Puerto Rico and District of Columbia states, because they're for the very, you know, blunt edge reasons, because they would tend to vote Democratic. And believe me, and one thing I might note, this is not, there's historical precedent for this. In the late 1800s, when the Republican Party was flagging and losing a lot of elections, having a hard time getting traction, they spearheaded bringing North and South Dakota and Idaho into the Union, because they knew they'd be Republican, trusted Republican states. And they did. And they have been for the most part. So I do think expanding the number of justices on the court, which can be done as a matter of legislation. The Constitution does not specify 9 people on the court, and the court over the years has not always been 9 members. So I think that's a possibility. I also think if there's the backlash that Douthit and Hassan and others sort of see building here, if that happens, it may be a while, but I do think you might find 60 votes in the Senate to reestablish abortion rights. It's going to take several election cycles that might be complicated by gerrymandering and access to the ballot box and so forth. But you know, the Mississippi lawyer needs to be careful for what they ask, because he kept saying, oh, let the people decide, put this back in the states. Well, okay, do that. Because if you had a free and fair election on abortion in Kansas, abortion rights would win every time. But if you rig it so that you run the election in a primary where you only have, if you're lucky, 20% turnout, it's hard to say that that's an accurate reflection of where the body politic stands on any issue, let alone something as weighty as abortion. So yes, Evelyn, I think that the possibility of altering the composition, or I should say the number of justices on the court, you'll hear that discussion come up more. And it's sort of out of desperation. You know, what are we going to do? And because Evelyn, when you said, it got me thinking about, you know, what to do about the court. I think many people will join you in that if Roe goes down.
Judy Ansel. Hello, Judy.
Hi, Craig. Great to see you.
Hi, Judy.
Hi, everybody. And yeah, so I'm speaking here as a Kansan who is thinking that I'm probably going to devote some part of the next year to fighting to save our constitutional provisions. And so I wanted to ask you for some advice. I mean, frankly, you know, I listened to the arguments at the Supreme Court and I felt outraged that these guys, mostly guys who are so unrepresentative of where this country is at, can take away a fundamental right from women. And, you know, I want to spread that outrage. Part of our problem, I think, is that the court isn't going to make a decision until the summer. And that only gives us like 2 months, maybe.
About maybe less.
Maybe less.
Could be the end of June.
Yeah. So what do you see are the opportunities here for organizing to win this thing in August? And what do you think are the obstacles? You already said some of those.
Right. Well, I know ACLU and Trust Women and a number of other organizations are trying to pull together kind of a unified effort
Right.
to, bring resources and energy to this. And because the theory, and I think it's correct, is if people know what's at stake, they will probably do what they don't generally do: go vote in a primary.
Let's
And
hope.
this may motivate many people who are otherwise no-shows on primaries to go and vote. So I do know those organizations are trying to pull together advocacy and,
Right.
and organizing around it. I think that this is going to get to be a very personal kind of effort, because abortion is something that a lot of people. Let me put it this way: I will really be interested to see how the anti-vax and anti-mask people come down on abortion rights, because what are they always talking about? Bodily autonomy.
Mhm.
Don't let the government tell me what to do here. Well, I hope they remember that on August 2 of 2022, if they're Kansans, and they show up and vote accordingly. My experience is that libertarians, for the most part, are pro-choice,
Mhm.
for the simple reason that they don't like the government interfering in anything that looks like a personal right. And that would include abortion. So there may be a critical mass of people in Kansas in any given day that we could say amount to about anywhere from 55 to 60% of people that would be in favor of retaining abortion rights. What that looks like on in August is hard to know. I do know that there will be efforts to drive up participation in that. So I think the obstacle is really structural. We're having a dadgum election in a primary the first week of August, and we're gonna put a fundamental right on a primary ballot in August. And when confronted with that argument in the legislature, the proponents of the constitutional amendment to restrict access, they said, whoa, well, we have to do this as soon as possible because there are so many lives at stake. We're trying to save women out here. I'm serious. They said it with a straight face.
Yeah.
Never once did they acknowledge that the likelihood of them getting a successful outcome was increased immeasurably by rigging this thing to put it on a primary ballot. They would not accept that the appearance of that just the mere appearance of it looked like it was trying to rig the outcome.
Do you think this thing will get a lot of national attention?
I do, particularly as the clock ticks down on the decision of Dobbs v. Jackson, because you're going to have these parallel processes going. The judicial process with Dobbs v. Jackson, the political process going on in Kansas to try to roll back our constitutional right. And it's going to head for, they're on a collision course. And is there anything that the media like better than something that's on a collision course? I don't think so. I mean, this is, so I think it'll get a lot of attention. And the more attention it gets, the greater the likelihood of that election on that day turning out to repeal this proposed constitutional amendment to essentially ban access. One thing, Judy, which I'm really glad you brought up, one of what the obstacles might be. One of the things you're going to hear anti-choice people say is, well, we don't have the right in our state to regulate abortion. Let me tell you, if they don't have the right to regulate abortion, I did a hell of a lot of work all those years for nothing. And my client went through a lot of effort and went through a lot of resources for nothing. In fact, you can go to the statutes of this state and see page after page after page of restrictions, some of them quite silly and ridiculous, including the size of the font that must be used on a consent form for a woman to get an abortion. The size of the font. Now, what does that have to do with the health of the woman? These waiting restrictions, what does that have to do with the health of a woman? So I do think that as attention is drawn to this, others may consider some of these restrictions just as silly as personally I do. But I think that you're going to hear some other very spurious arguments from the anti-choice side. Not only that, oh, we have to do this in order to have the right to regulate. That's nonsense. And they're willing to perpetuate these kinds of falsehoods, these kinds of misstatements in order to get their point across. And I think that I'm hopeful, at any rate, that people in Kansas won't fall for this. And of course, here's the thing. Let's say the election turns out well for abortion rights. Possible. Let's say that it does. That, of course, gets us back to what does the anti-choice side do then? Historically, when the anti-choice side feels as if they've not got any options in the judicial branch,
They get violent.
or they don't have any in the political branches, they do. They resort to violence. I represented George Tiller at one point.
Mhm.
He told me, all I want to do is practice medicine. I want to go out and help women. It's all I'm looking to do. And other providers will say the same thing. But we know attacks on clinics are common, or they happen. And I have to think that the frustration that might be felt if Roe does not go down, or if the election in Kansas turns out to protect abortion rights, there will be a response to that as well. Hopefully it'll be peaceful and orderly and civil, but historically it's not always been.
Lon Swearingen.
What I have is a simple question, and not simple in the sense, but time-wise, and that is, why not term limits for the courts? Because what we've got is a program to put people on the court, like what has happened with 3 of them in the last year or so. And that's what I'm asking, is there a way to do that simpler than trying to stack the court?
Yeah. Well, it'd be a political decision. I suppose that if somebody like Schumer and Pelosi came out and said, all right, look, here's the deal. Women are underrepresented on the court, or we think that there ought to be more women on the court, and they're sending a signal to the next president, don't send a male down here to be appointed to the court because we're not going to confirm him. That would be possible. That would be a very overt move, but desperate people do desperate things, and in the desperation to protect abortion rights, I'm not sure what all will be on the table.
All right, I was just curious.
Yeah, good question.